We in Australia, and I suspect in much of Europe and the Western world, find the whole Roe versus Wade and its overturning difficult to understand because it goes to the issue of who makes major decisions like this more than what the decisions are, if I can put it crudely, as I understand it. But you've been writing about this since right back at the time of the original decision. So can we begin? I thought it was extraordinary that in the build-up to the much anticipated decision that overturned the famous Roe versus Wade decision, and that was, of course, the Dobbs versus Jackson decision, the whole thing was leaked to the media, an outlet called Politico, the month before it was to be officially announced in June of this year. That created something, as we see it from the other side of the pond, to a great media sensation, an immediate popular rejoicing on one hand, and enormous protest on the other. This is pretty interesting stuff, the leaking of a major decision like this. Any thoughts on why it was leaked and who was looking to gain by it, what they were hoping to achieve?
Well, first of all, nobody has ever identified the person who is responsible for the leak, although everybody knows that it has to be someone. There is speculation that the leak was by one of the justices, highly unlikely, by one of the clerks, more likely, by one of the other people who work in the Supreme Court who are not particularly a clerk or a judge, one of the functionaries, office members, and so forth. And nobody knows. The next question is which side leaked it. I think most people believe that it was the pro-abortion forces that did it, in the hope that they would be able to create such a stir that they would get one or more of the Supreme Court justices, actually they would need two, to change their positions so that Roe would be allowed to live on to fight yet another day. Nobody can prove that, but let's put it in this particular fashion. The conservatives never mobilized in a kind of political fashion. And so it wasn't as though once the decision came out, you saw large numbers of conservative crowds out there cheering it on. But the progressives are much more prone to take to the streets. They've done it both before this decision was come down, and they've continued to do it afterwards. And the theory was that it would be a combination of public awareness on the one hand and intimidation on the other hand that might lead it to tip the balance. I think the psychology that they had on this, if this was the psychology, was misguided. My sense is that most people in the position of Supreme Court justices would, if anything, become more rigid and more stubborn on the particular issue if it turned out they believed that they were being subject to external pressures of one kind or another. So as best we can tell, nothing really shifted. There was a 5-1 split on the majority side. Chief Justice Roberts desperately wanted to split the baby and to sort of move the period at which you could have an abortion back from, say, 23 weeks to 15 weeks or 10 weeks, whatever it is. The other 5 basically took the position that Roe was essentially corrupt root and branch. And so what they said is they wanted to turn it to the legislature. And just by way of an observation, I don't know if you know this, but my initial legal training is that of an Englishman. I studied law first at Oxford in 1964 to 66 and was very much schooled in the system of parliamentary supremacy, which dominates that particular company. And so it took me a little time to get used to the American tradition, which does have this sort of erratic and inconsistent form of judicial intervention. Everybody believes in 2 propositions. One is that major political decisions ought to be made by the political branches of government, except when fundamental rights are involved. What they disagree about is what are the fundamental rights that are involved in some of these cases. And so what happens is we go both ways. If you're trying to talk about guns, which is another one of the issues that came up, the progressive left said this is the kind of complex issue that just has to be left to the legislature. Don't sell me anything, a bill of goods about the Second Amendment and the right to keep and bear arms. And then all of a sudden the roles switch when you start dealing with the abortion cases. So this is a long-standing problem that we have in our particular country. And the impatience that one sees it being addressed with, mainly on the progressive side at this point in time, gives you pause as to how long we could keep this ship of state together, given the huge stresses that have been placed upon it.
Yeah, because it's worth making the point, I think, that Australia's a federation, unlike Britain. But in this country, in the same way as in Britain, the parliaments are supreme. They've made the laws. The parliamentarians who make those laws are then accountable to the people. And the courts essentially keep to interpreting the law, although there's always a bit of controversy around the edges on it. The critical point that in a way illustrates this is that I suspect most Australians would know the names of more American Supreme Court judges than they would its equivalent in Australia, because in Australia it's not politicised in the same way.
No. I mean, look, when I grew up, Fuller and Dixon were the two judges that were most known through the Privy Council and so forth. And they were private law experts whose judgments were strong enough that you actually read them as a student when you were in England. But in the United States, it has always been a case that constitutional issues start to matter, not just on the structural issues where they still matter in Australia, but also on individual rights. And in 1973, when the decision first came down, the basic conundrum that most people faced was as follows. As early as 1905, the most emblematic case, but not the sole case, involving the constitutional protection of economic liberties was a case called Lochner against New York, which held by a 5-4 vote, so you know it was tense, that any statute which imposed a maximum hours law of 10 hours per day or 60 hours per week was an interference with the freedom of contract that people had. It's a decision that I supported under the American Constitution, but was highly unfavorably received by most. And the first progressive wave in the New Deal unceremoniously overturned that decision somewhere between 1937 and 1941. 1967 comes along, and there's a case called Griswold against Connecticut, in which the statute at stake is one that prohibits the sales of contraceptives even to married couples. And what the Supreme Court did, chiefly through Justice William O. Douglas, was to say that there was something either in the Due Process Clause or in the Ninth Amendment about reserved rights, which meant that this statute was an interference with private liberty. And immediately, most of the Democrats, liberals, there were no progressives at that time in the sense that we use the term today, said, wait a second, we decided in the Lochner decision and all those cases that this is all to be left to the legislature. Now we're turning around on contraceptives. How can we possibly do this? And there was a big fight as to whether or not rights about reproduction and so forth would be appropriate. That case was narrowly decided, applied only to marital couples. Within 5 years, it applied to all people. Why, then you would ask, did it not create this huge response? Because essentially, Griswold was a mop-up operation. At that time, every state but one had allowed the sale of contraceptives. And so this was not trying to force people into a different path. It was essentially finishing the job, as it were. When you got to Roe v. Wade, this has always been contentious, but I think every state in the union had some statute which made at least some abortions illegal, although there were some variations amongst them. And as one of my colleagues from Chicago, Jerry Rosenberg, always likes to point out, in 1972, there were in fact 250,000 legal abortions in the United States, given all the loopholes. But what Roe did is it simply said, we're going not from 49 to 50 states, we're going from 0 to 50. And it turns out that's a much more controversial issue. It's not just Catholics, it's all sort of traditional moralists who are trying to figure out when does human life begin. And one of the answers that's always on the table is at the time of conception, on the theory that's the one discontinuous event that exists. Before conception, there are a lot of gametes out there. It doesn't mean much. After conception, there's only one that's allowed, one thing there. And, well, therefore, you become a Catholic and say you can't do it later. And the other people said, no, we have to do it a little bit later, and there'd be more compromise. There were all sorts of debates about this. And in the end, what the Supreme Court decided in Roe is that it's a matter of trimesters. Can't do anything in the first trimester, can regulate safety in the second trimester, and can regulate anything in the third trimester. And so, as Phil Kerwin said when I wrote my paper many years ago, where in fact does the Constitution and the Due Process Clause supply us with guides as to what the trimesters ought to be. So most academics at that time, whether they were pro or anti-abortion rights, sort of came to the conclusion that this was a judicial excess. But somehow or other, as the precedent became more heavily entrenched, all of these initial doubts started to disappear. It was no longer comparing economic liberties against reproductive rights. It was just a very bold assertion that there's a fundamental right that each woman has, given her personal autonomy, to decide whether and if so when to terminate a pregnancy. And in fact, the political side of this has been more protective of the abortion right than was the decision, because if you looked at the recent effort in the Congress to worry about this and to codify the sort of the pro-Roe sentiment, they were willing to say you could have an abortion up to birth. 38 weeks is something you really think ought to be there. So we are essentially in a huge state of intellectual disagreement. And the way I like to sort of summarize my views is, as I said, when I wrote about this opinion in 1973, I was, like many other people, very critical of it, more on the moral grounds than on the institutional grounds that you referred to. And, you had that particular debate. But when you try to overturn a precedent of 49 years, the joke that I always used to say was, on Monday, Wednesday, and Friday, it's such a terrible decision, you overturn it. And on Tuesday, Thursdays, and Saturday, it turns out that it's an established precedent. You dare not do it. And on Sunday, you give up and you don't think about the issue. And so I think, I'm one of the kind of few relatively so-called conservatives. I'm more of a classical liberal voices, which was generally torn by this situation. Most of the conservative press has only the reaction good riddance. The religious press, particularly on the Catholic side, said this is only the way to restore on the dignity to all persons, born or unborn. And so what you do is you see this really polar divide, and there's very little chance of getting compromise. And so that's why you see people taking to the streets.